Well, for law enforcement, the Fourth, Fifth, and Sixth Amendments set up operating rules that tell them what they can and cannot do in being the tip of the spear of the terrible engine of the criminal justice system, to use a phrase that you sometimes see littered around Supreme Court opinions. And so law enforcement officers have to know those rights, because the limit of someone's power is the boundary of the rights of the people who are affected by that power. But for the general population, unless they live in a community where the relationship with the police is one of constant friction, we tend to forget that rights are what makes us able to order the way we live in the way that we do.
The Sixth Amendment specifically says that every criminal defendant shall have the right to assistance of counsel for his defense. Now, at a basic level, that seems just intuitive, right? I mean, of course you can have a lawyer in there, but that was not always the case. There have been times in the not-so-distant past where people accused of crimes weren't even allowed to bring lawyers with them, even if they could afford them. The Sixth Amendment remedied that right off the bat. Yes, you do have a right to have counsel in there with you if you're accused of a crime, but only if you could pay for it, or only if you could convince some lawyer to do it for free. This created an obvious unfairness, and there were legions of cases where people were convicted of heinous crimes, accused and convicted of terrible crimes, and put in jail for long periods of time without any lawyer defending them. Eventually, in the landmark case of Gideon versus Wainwright, the Supreme Court of the United States decided that this was no longer tolerable, and that it was going to interpret the Sixth Amendment's right to counsel as requiring any government that's trying to put you on trial for a crime to provide you with a lawyer for free if you are indigent, if you're poor. This has been a revolutionary holding. Cities, towns, municipalities all over the country now either have to have public defenders who defend people for free, or they have to have court-appointed counsel. And I think most of us would agree that even though it's a very expensive thing for the government to have to provide this, that it really and truly is an essential aspect of being fair to people who are accused of crimes.
The history of the Sixth Amendment in the United States shows that we took a much different view of the importance of a defense attorney than did our English forebears. In England, at the time of the Constitution, if you were charged with a felony and a serious crime, a crime for which the only authorized punishment was execution, you didn't get a lawyer. So you had to go into court, and at the trial where you were going to possibly forfeit your life, you didn't have a professional who was an objective person who could help you argue your case, but you faced someone on the other side who represented the Crown, who was a trained lawyer. Every colony prior to the adoption of the Constitution rejected this view. Everyone in the colonies, and ultimately in the Sixth Amendment to the United States Constitution, agreed you could not make the process remotely fair without giving the people who are on trial for their liberty or their lives a trained advocate in the law, so that that person had a chance to be able to get all of the advantages that the system built in. The system gives you the right to a public trial, the right to a speedy trial, the right to confront the witnesses against you, the right to compel the court to bring witnesses in so that you can present your own defense. Those rights are essentially meaningless if you don't give people a lawyer, because people on trial for their own lives or liberty without any legal training just don't have the ability to get access to those promises. So it's a question of basic fairness that led to the adoption in the Sixth Amendment of the right to the assistance of counsel. It's the key to unlocking all the other doors.
We've talked about due process of law, which appears in the Fifth and the 14th Amendments. One way to think of the Sixth Amendment to the Constitution as an elaboration on what due process of law means in the context of a criminal case. So you've got specific procedural rights in there. You've got a right to a speedy and a public trial. You've got a right to counsel. You've got a right to compulsory process to compel witnesses in your favor to come and testify. These are all procedural protections that, again, are probably included or at least contemplated within the general concept of due process of law, but the founders thought that they were so important that they wanted to spell them out.